Res ipsa loquitur is a maxim in tort law. The phrase derives from Latin and a strict translation is, "the thing speaks for itself." In tort law, the maxim applies to infer liability in the absence of proof, where it is obvious that such matters do not happen unless there has been negligent conduct. For example, a surgeon leaving a scalpel inside a patient. The case of Scott v. London and St. Catherine Docks established that in order for res ipsa loquitur to operate, there are two requirements. 1. The defendant must be in a position of control. 2. The incident is one that cannot easily be accounted for, as it generally would not happen in the absence of carelessness. Where these requirements are met, the claimant is relieved from having to prove the defendant's breach of duty. The negligent conduct is inferred from the circumstances and the burden of proof is reversed. The defendant is presumed liable unless they can demonstrate they exercised reasonable care. In Scott v. London and St. Catherine Docks, the claimant was struck by a large bag of sugar which fell from a crane. The claimant was unable to prove what caused the bag to fall from the crane. The court applied res ipsa loquitur and the court inferred there must have been a breach of duty to allow the bags to fall from the crane. Other case examples include Colville v. Devine 1969, where the claimant suffered a personal injury escaping from an explosion at the defendant's steelworks. The claimant was unable to show what had caused the explosion. In Ward v. Tesco Stores 1976, the claimant slipped on some yogurt on the supermarket floor. The defendant was unable to show that they had cleaned the spillage in a timely manner. A further illustration can be seen in G v. Metropolitan Railway, where the claimant fell from a train when the door opened unexpectedly shortly after it left the station. The driver operated the doors, meaning the railway company were in a position of control. The defendant was liable as this raised res ipsa loquitur. This contrasts with the position in Eason v. LNER, where the claimant fell out of a train door. The defendant was not liable as the doors were manually operated by passengers, so res ipsa loquitur did not apply. In summary, res ipsa loquitur means the thing speaks for itself. It applies where the defendant is in a position of control and the event is one that doesn't generally happen unless there is lack of care. The claimant is then relieved from proving breach of duty as the negligence is inferred and the burden of proof is reversed. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.